Okay, let's call this meeting to order, the Ethics Board, and I reviewed the previous minutes. They look fine to me.
Thank you.
Any changes? I move that we approve them. Second, all in favor? Aye.
Aye.
Any public comments? Gordon, do you want to start us off with public comments? Or?
No, keep doing what you're doing.
Okay, we're happy to have Gordon here, and Amber's out of town trying to save some grant with Lee Zeldin. So she wishes she could be here, but we have a vacancy. That chair over there is vacant.
I missed Johnny already.
And it was so nice to have her. There's been some question if we have to have a town employee.
I think that's what the code says.
It's
Well, that's what
not
I-
only what the code says, but according to what I found, it's what the state law says.
Well, that's probably how it got into the code.
Yeah.
It's what the state law says, except that the town can and should use its home rule authority to deviate from the state law on that point. And I've already discussed that matter with the town board, and they are in agreement with you. We have discussed, this board has discussed it previously also, that for a variety of reasons, even though I think Christina is fantastic and a great asset to any body that she belongs to, I think not having a town employee advances a couple of goals. One is, in particular, you want people to seek the advice of the Board of Ethics, believing and understanding and accepting that their request for advice will be confidential. And including a town employee on the board kind of is at war with that that sense of reassurance. And well, that's the primary reason. So yeah,
It's no problem being able to deviate from that legally?
it is no problem provided you deviate from provide the legislative body, the town board, invokes the powers under the home rule law. They can do that.
Other towns, comparable towns have done that.
All of the municipalities that I represent have done that,
Great.
including the county of Westchester, the town of Hempstead, the town of Oyster Bay, the town of Huntington, and the town of Southampton, and several villages.
So we would have to apply to the town board to take that action.
No, what I think you would do is we will, once we finish with these discussions, I would propose that we prepare an amendment, a comprehensive amendment to the existing code of ethics and submit it to the town board for their review, and if they're in agreement, their adoption.
Okay, for practical purposes, I like that idea. I mean, we got 162 town employees, full and part-time, so it's who we would have to try to draw from. There's no obvious candidates.
Christina do?
Except for Christine, who's not currently a resident.
I am. Currently, I am.
And it makes some sense. What do you guys think?
I just think that Shelby brought a lot to the table in terms of her knowledge from the clerk's office.
Yeah.
And so
Right,
somebody
right.
in that office was very helpful. Christina's always really helpful.
Yeah.
There's a way to address that, though, and that is the town board can appoint a liaison to the Board of Ethics. In the town of Southampton, for example, the deputy town attorney, Kathleen Murray, attends all of the meetings of the Board of Ethics, coordinates with me, and when there's a need for her to do it, she recuses herself. Well, she doesn't need to recuse herself because she's not actually a member of the board. She steps out of the room. She leaves the meeting when there's a matter for discussion that is appropriate for her to refrain from participating.
Yeah.
Yeah.
My my feeling, just having thought about this since yesterday for 5 minutes, is as long as we get a confidential secretary that's totally confidential, that also has institutional knowledge, we have that. It was great having Shelby too.
Yeah,
What do you think?
I want to know what the confidential secretary thinks, if she would feel more
Valued if she was on the board.
But she can't, she's
Yeah,
not.
she's gonna move off, yeah,
Oh,
Yeah,
the
what do you
residence
think?
requirement will be.
Hmm?
as a president.
What I think, I don't know. I didn't think of it, to be honest.
okay, whatever. I don't feel strongly about it.
Bob, what do you think about this?
Yeah, no, I'm fine with it. I do think, I haven't looked at that list, but,
Yeah.
there may be people on those, when you say town employee, you would consider me a town employee because I'm on it. So are there people on this list that are also volunteers?
Does our code says full-time employees
Or
or?
these are just
I
full-time?
was gonna ask Stephen that, who qualifies under the state law as an employee or official? Is it just paid employees or volunteers?
Well, it depends upon the context in which you're using the term. I would say for purposes of the code of ethics, you don't want someone on the Board of Ethics also holding another town position, whether that be as an employee in the labor law sense of that term, or an officer and employee in the code of ethics sense of that term, which includes board members.
Okay, we understand your reasoning and that your other towns all have gone away from that.
Right.
If technically that state law was applied without an deviation, who would qualify as an employee and official?
I think somebody receiving wages from the town, somebody who receives a W-2 at the end of the year.
Yeah. It'd be this 160 people probably.
Yeah, I mean, there are.
And I was thinking, as I was thinking about this vacancy, who would want to do that? You know, I talked to Shelby, she said, you know, it's good to have the institutional knowledge. On the other hand, it can be a little awkward if you're,
Still working.
if you're ruling on a friend of a friend or whatever.
Mhm.
Yeah.
I was thinking, well, who'd be good? Maybe a police officer or somebody.
Or clerk in the police department or,
Oh, I think a police officer would be a terrible person to put on the board.
Yeah,
That would heighten the fear of people coming to the Board of Ethics with their requests for advice.
Do you have any thoughts about people in general?
I hadn't thought about it because I
Yes,
was
yeah.
expecting that we were gonna do an employee.
Uh-huh.
Obviously, having the island open, it opens up, you know, a better universe. And it would be nice if it was somebody that has to keep a secret, if they have some ethics
right.
at mind. If they have any legal training, that's great. If they're a resident, that's a bonus because then we can get quorums. What do you think?
I don't have it. I hadn't thought about it at all.
Yeah, I haven't either.
You know, I'm just looking through this list and there might be plenty of people.
We should probably
Let's just-
advertise internally and.
I'm sorry, folks. So the appointment to the board is not for the Board of Ethics. It's for the town board. You really don't need to spend your time considering who might be a candidate for appointment to the Board of Ethics. That's not within your jurisdiction.
Yeah, we know that, but it doesn't hurt to brainstorm a little bit and to encourage people to apply if there's good candidates.
And I would assume that the town board would like our input.
Right.
Yeah,
Yeah, Duff is typically present during the interview.
yeah, so I've been involved in that. So let's,
I can just,
what,
it's just struggling because we were talking about social work. I said the town has social work, but that might be.
Yeah, well, what we will probably do is that we will internally advertise to all employees that there is an opening and we'll see what traction we get, whether anybody's interested to serve. It's a volunteer position, so it's not paid for the employee.
Right. yeah. Stephen feels strongly it should be non-employee.
I gather. It doesn't matter to me.
I can see the reasoning behind that, especially if we
Yeah.
have a, confidential employee and a town attorney. We have two employees right there.
Yeah, I know people have come to me and said, how do you get on the ethics? Not, so
Yeah,
I know there are plenty of people who would like to be on the board.
yeah, yeah. So Stephen, recognizing that we don't appoint the person, we do recommend to the town board changes to our code, and we're in the process of that. And this would be one of the changes. Deborah, what do you think?
Microphone.
I know, I'm sorry, I'm busily trying to get off of my iPad and onto the main computer and I'm struggling, so I apologize for that. I think that as long as Christina, I agree about the insider knowledge and that it's crucial to us because none of us know what, either Christina or Shelby know, but that if we can get it from Christina, we'll be okay. So we needn't do it. And I thought what Stephen said was really interesting. It had never occurred to me that some people may be afraid of having a some people may be afraid to come forward based on there being a town employee as one of our members, which wouldn't have occurred to me.
Okay, well, I think there's pretty close to consensus to move that way.
Yeah.
Right?
Mm-hmm.
And so hopefully we'll get close to consensus on other recommended changes to the code that we're able to take to the town board pretty soon. And as part of that, we want to look at the preliminary list that we had from last meeting, and for Stephen to review I think this is the Southampton code that you annotated, Stephen.
Yeah, well, that it is. I also would like to just quickly walk through the existing Shelter Island code to let you know I did it very superficially last time to give you some of the areas in which I think some work would be beneficial.
Great. So what's the best way to approach that? To start with the Shelter Island?
Yes, I think that would be a good idea. I want to preface this to say that I have a tremendous respect for this board, and it's obvious that you did a lot of work on this code and you produced an excellent work product. I think that you would have benefited by a little bit more legal guidance as you went through that process. But this is, as local municipal codes go, I think this is a very good one. But that having been said, we did discuss last time, and it's on your preliminary list, about eliminating unnecessary definitions, which in my view are a trap for the unwary. If terms require definition, they should be defined in context. Otherwise, someone who's reading the law and is not aware of the fact that a term is defined elsewhere in the code may be misled in their interpretation of the law. So the only terms that I define in the codes that I draft are interest and relative. Interest has a very specific definition set forth in Article 18 of the General Municipal Law, and I think it is best, in order to avoid inconsistencies between the local law and the state law, to hew as closely as possible to the definition of that term set forth in the state law. And the definition that I use, not dissimilar to the one that you have come up with, is interest means a direct or indirect financial or material benefit. And that comes directly from Article 18, as does the rest, but I've inserted, but does not include any benefit arising from the provision or receipt of any services generally available to residents or taxpayers of the town or an area of the town or a lawful class of such residents or taxpayers. You've included that concept in your definition. Then the definition goes on to say something that you have elsewhere in the code. A town officer or employee is deemed to have an interest in any private organization when he or she, his or her spouse or dependent, is owner, partner, member, director, officer, employee, or directly or indirectly owns or controls more than 5% of the organization's equity or debt, whether in the form of outstanding stock or otherwise. Now, that language comes from the state law, and I really think you should use that language so that there is consistency between the town definition and the state law definition.
See, I
that-
think can I just interrupt for a second?
Yes,
I think you're sort of conflating the two. We use the term financial benefit,
Right.
and you use that as an interest, which
Right.
I think the code does, the state code does too, which is kind of confusing to me. But we do include in that definition what you describe as a financial. We took out the language about material because I don't know what material means, but if you want to stick with that, that's okay with me. But then down below, we talk about interest in a contract and interest in a private organization. So there's also the situation where interest in a contract is a different definition than interest in a private organization. So,
yes, the rule for contract is very specific.
right,
And comes from the state law. You see,
Right.
I don't think you should really tamper with something like that. It's a misdemeanor to violate the state law. It's a crime.
I
So
know,
if
and
your
we-
code deviates from the language of the state law, you're setting up potential conflicts and inconsistencies and perhaps setting traps for officers and employees.
okay.
So
I
think
don't,
it-
I
go
don't
ahead.
think, I don't think that definition of interest in a contract deviates from the state law. I think we got that directly from the state law.
Right, but if you've got interest, you should leave the definition of interest the way it is set forth in state law. And then when you talk about prohibited interests of in contracts, you say that you're deemed to have an interest in the contract of your spouse, you're deemed to have an interest in the contract of a dependent or household member, or a business that you you see that language, that last sentence in the definition of interest that you see in the Southampton Code has all those concepts from the state law in it that relate to contracts, interests and contracts.
Yeah, interest is defined on the page 4 of the Southampton code. And
Right, so
it-
you don't have multiple definitions. That leads to confusion.
Right, so what you're suggesting is that we would define interest exactly as that, as so shown there. And we would have the interest in a contract and in a financial organization, not in the definitions, but in the context of the code where they arise.
If that's required, but those concepts do appear in this definition of interest.
Deborah?
Thank you. I'm not, I can't address the interest thing, that I don't understand, but it was the list of who counted as a person related who has an interest, and you said just spouse or dependent. And I think we had wanted to expand that. Is that an expandable list? Like
Yes.
sibling or parent, or that was my only comment on what you read to us.
Yes, you can expand the list. You can make the Town of Shelter Island Code more prohibitive, more restrictive than the state law. You just can't allow conduct that the state law prohibits. But you need to be careful. You need to think these things through because, for example, this rule about prohibited interests in contracts limits the people and organizations that the town is permitted by law to enter into contracts with. And you don't necessarily, even if, for example, they use sealed competitive bids, even if someone on the list that of people and entities that you're precluding is the lowest responsible bidder in a procurement process that is sealed and confidential, and the awarding agency, the town board, doesn't know that the identity of the
Uh-huh.
person.
No, I see where you're going with this. Yeah.
So,
No, just,
and in a municipality, Shelter Island, look, in Nassau County, there are countless sources for any goods or services that you may want to procure. In an upstate rural municipality, that's not the case. And on the island of Shelter Island, it may not be the case. There may be a limited source of certain
I want-
services.
Stephen, I want to take a moment to address what Deborah brought up, which deals with largely with the definition of a relative that's also covered. We use the minimum number of relatives allowed under state law. This is in there's a document that's identified on the web as what we gave to the town board when our code was adopted. And the first page of it says preamble, and it's one of the discussion documents on the web. And the next to last page of it is the relatives chart, basically, which shows that our general conflict of interest provisions applying to discretionary acts apply to a limited number of people. That is just the limit in the state law 18806. And then it shows that the contract's spending interest, which is more restricted because it's prohibition in some cases, it only applies to employee, spouse, minor child, and dependents.
That's the interest in the contract.
Yeah, that's right, which is more restricted because
Because it doesn't, that's the only purpose for including a dependent in the definition of relative, as far as I can tell.
No, it's not. It's not at all. And we're muddling up the definition of relative, which applies to a variety of situations under the code, with the rules related to prohibited interests in contracts.
Right.
And that's one of the problems with this code. It muddles these things. I didn't realize that we had shifted from a discussion of the rules regarding prohibited interests in contracts to the definition of relative. If you want to expand the definition of relative, that's absolutely fine. I said at the last meeting that that's a matter of judgment. That's a judgment call. How widely you want to cast the net in defining the term relative. But the relevance of the term relative is that a town officer or employee may not use their official town powers and duties to confer a benefit on a relative. That's a different concept and a different rule than the rules related to prohibited interests in contracts. So
I understand that, Stephen.
So are you saying we should have different definitions of relative for different situations?
no, I don't. Look,
I'm sorry.
I think that what this board really should do and would really be beneficial is start with the Southampton Code and go through it and decide what they think should be different in Shelter Island than what they have.
Just so you know, we did this once.
Did this.
Years ago, we did do this.
I know,
Yeah,
but, I mean, I find many issues with the code as it was adopted. And, you know, I've marked it up and let's get past these definitions.
Yeah.
Well, can I just ask you a question? Because you do say that that dependents shouldn't be included in the definition of relative.
Yes.
And yet your definition of relative includes it dependent. So I'm very confused.
No. Actually, what I said was member of household should not be included with in the definition of relative. And I would have no problem taking the word dependent out of the definition, provided that elsewhere in the code, when you say relative, instead you say relative, dependent, or member of the household.
If we want to expand it, yeah.
What we wanted to achieve is clarity. And the reason I say household member should not be in the definition of relative, and maybe you're right, maybe the same concept applies to dependent, is that when people use plain English language definitions of the word relative, they're not including members of the household who are unrelated. So yeah, that's the issue. You don't want definitions to deviate from people's normal plain language understanding of the meaning of a word, because if it does, you're adding confusion to the law.
Okay, it will help us all when we get this in black and white. So I think a goal at some point should be a markup that we can review. Let's keep moving through the Shelter Island Code.
Okay. 8-4. 8-4, I think, is less clear than the provision that you will find at 23-4 in the Southampton Code. No person or employee shall use their town position or official powers and duties to secure a financial benefit for themselves, a relative, or any private organization in which the employee is deemed to have an interest. That may be understood by a lawyer. That's not going to be understood by a rank and file employee of the village of the town of Shelter Island. Not unless they're savvy enough to find elsewhere in the code what private organizations they're deemed to have an interest in.
Okay, which is one of the things on the list that we wanted to.
Right. But if you look at the way it's framed at 23-4 in the Southampton Code, I think it's laid out very clearly, and it's more comprehensive than the provision in the Shelter Island Code. So I'll move on.
But can I just say, but you say you list them, and that's great. I agree that that's clearer. But then you say any private organization in which she or she has an interest.
Yes.
And
And
then you
interest is
don't-
a defined term.
I know, and
capitalized-
it's-
Go ahead.
No, I see.
Which is the same in the Shelter Island Code. We just have one sentence, and the Southampton Code has a list of A through F.
Okay.
We took it from Southampton Code.
Well, the start of it, and then
Yeah,
we,
in the beginning.
okay,
So then I'm looking at 8-5. Whenever a matter requiring the exercise of discretion comes before an officer or employee that could result in a financial benefit to the officer or employee, a relative of theirs, etc., disclosure is required. Disclosure is required in, first of all, when I draft a code of ethics, it has 3 separate and distinct sections or groups of sections. The first is the code of conduct. The second, separately stated in its own section, sub-chapter, or I'm losing the term, but separately, a separate part of the code are the disclosure requirements. And the third separate and distinct part of the code are the administrative provisions, the establishment of the Board of Ethics, the powers and duties of the board, and so forth. Penalties, training, all of those things. So I would move disclosure to its own separate part of the code. And disclosure is required when somebody recuses themselves. When somebody recuses themselves, they're required to make what is called a transactional disclosure. When someone has an interest in legislation that's under consideration by the town board, they're required to disclose that. They are required to disclose if there's a disclosure requirement for applicants and land use applications that's entirely separate. And then there's a provision that you do not have in your code and you don't need to have, which is annual financial disclosure.
Right.
So, yeah, and
Even that sounds quite similar to what we have in 8.5. And I
Right.
don't know that we need to break that out into a whole new section. I do think that as we talked about before, that we need to eliminate the stuff that we're not really doing in disclosure and just, in other words, collecting forms. We're not collecting forms.
right.
It should be in minutes and it should be disclosed to supervisors. What do you guys think about that?
We discussed that at length.
Yeah. So I think unless there's more to disclosure, because we're not doing annual advanced disclosure in a small town like this.
Yeah.
People want to, it would be a nightmare.
Would be nice.
But we are doing what you call transactional disclosure, and it's described in 8.5, I think.
Yeah, 8.5A at the end, on the top, well, I have it on top of the following page. The timing when they acquire knowledge of the benefit requiring disclosure, it's not a benefit really, it's an interest requiring disclosure.
Yeah. Yeah, if we went with interest instead of financial benefit as the
Right.
triggering word, we would
Yes.
change that to interest.
I think
Yes,
that's a good idea.
So I think that's a part of this is,
So it could result in an interest to the officer or employee.
right.
right, I mean, if we trigger with interest instead of financial benefit, we talked about this a lot because interest, so indirect and what's that term?
Material.
Material interests, people don't understand that, so we went with financial benefit because
I
that's,
think is clearer than interest.
but Stephen feels.
Disagree.
But there are interests that don't involve a financial benefit.
Yeah.
I want
I
something to
know.
happen.
So why are we mixing up the definition of interest to include interest in organizations as well as financial benefits? I mean, I think,
Because financial benefit is a subcategory of interest.
I disagree. Anyway,
Well,
Go on.
I think it'll be good to get this in black and white. Or do you want to make a case now? I know that we're not,
well, I'm going to make the case now that the definition that you use of interest is conflates two different things.
let's compare that definition in the Southampton Code, it's on page 4,
Yeah,
with,
it means a benefit.
right,
So you have to disclose something if you have a potential interest in an action, right?
yeah.
And I would
But
say.
not
if it-
every interest involves a financial benefit. For
I
example,
know.
you,
You also use it to define whether or not you have an interest in an organization, whether that person should be,
Right,
your ownership of your interest in that organization should be attributed to you.
right,
And that's a different attribution from one organization to another is different than a financial benefit to yourself. Those are two different concepts, and they are conflated here that I don't know how to tease them apart.
they should not be teased apart. They should be included in the definition of interest, because what flows from the definition of interest are the situations in which you're required to recuse yourself. And that would be whether you received a financial benefit or have some other interest in the matter.
yeah, where is interest in a private organization is in our
Yes.
code in order to tease those apart.
Yes.
Where is that triggered? Is that a financial benefit to the private corporation?
Yeah, it's a benefit to if it benefits an organization in which you have an interest,
Yeah,
then that financial benefit is deemed to go to you. It's attributed to you.
right. I mean, aren't we kind of talking about the same thing?
I think we are, but I don't think that they're the same concept. But
No,
that's, I'm sorry.
One of them puts two together and we tease them apart for the reasons that we all know. Because they seem to be different things. Right?
Well, the interest in a contract is really on a separate table,
That's a separate thing.
and we really do deal with that separately.
Right.
An interest in a private organization is, trying to find,
It's that indirect interest. Do you have an interest in the yacht club, for instance? We shouldn't talk about specifics.
no, I'm just talking about a private company.
Yeah.
I'm sorry,
But it could apply to something like a club.
here, disclosure.
I think the yacht club was a really good example. It could apply to many people, including me, who are members of the yacht club. So that was a good one, Duff. Because there's no financial, at least
you-
direct.
85 says,
Yeah.
disclosure requirement is it could result in a financial benefit to the officer or employee, a relative of theirs, or any private organization in which they're deemed to have an interest.
Right.
Then you have to disclose. That's my understanding of why we're using where we're defining an interest in a private organization.
Right.
I don't think it has anything to do, that the interest as used in that part of the sentence has nothing to do with a financial benefit. It has to do whether you have an ownership interest in the entity. And that's an attribution principle.
That's saying a financial benefit to.
I know, above it doesn't.
an organization.
Exactly. And
So it's all,
otherwise we say an interest to a organization in which you have an interest. To me, it's a misuse of the term.
I mean,
I'm sorry,
we could define, I don't think financial benefit is defined in the Southampton section that Stephen.
I don't,
referred to.
no, they talk about.
It should not be, you should not think in terms of a financial benefit. It's too limiting. It's a financial or other material benefit.
Right, we can add
There
the
are other-
material word. That's possible. I just don't know what it means.
But it's not just, well, it means not de minimis. And you may
Okay.
be presented with a case in which you have to decide whether something is or is not de minimis. There's
Okay.
a certain amount of gray area and judgment involved in regulating ethics.
Okay.
And the idea of a financial or other material benefit clearly indicates that there are benefits that can be conferred on somebody by government that are not financial in nature. And
Service, for example.
I don't think we're that far,
Yeah, no, if you,
it's kind of a semantic.
Yeah, because we've had cases, and I won't mention specifics. Excuse me, that have, sorry, that have gone on that.
Yeah,
I have no problem with including material. Now that you've just defined it for me, I didn't know if it meant physical or not de minimis.
But I'm sorry, maybe I'm missing the point here, but I feel like, just to use the yacht club, let's just say you were going to be an officer in the yacht club. You're not going to make any money. It's an unpaid position, but you have a strong and abiding concern that the yacht club prosper, even if it's at the detriment of the community or whatever. So I feel like you need to pull anything that has to do with financial out of the interest, or it has to
right,
be more
Just-
in there than financial.
just at the last town board meeting, if you watched it, there was an application by a golf course that that was very controversial. Some people think that, the golf course should receive some benefit from the town, and other people think that it should not. And the town board's going to have to grapple with that and decide it. But there's another example.
okay. I'm personally happy to see this in black and white so that we can focus on the words. Okay, and then we'll come back on this. We'll see if it's a
We already
semantic
say
or
the
a
same
real
thing.
difference.
Okay.
I think we're talking about the same
Yeah, I
thing.
think-
Let's go ahead, Stephen.
Okay, 8-6 recusal and abstention. No officer or employee may participate in any decision or take any official action with respect to participate in the decision, I think is a little bit too limiting. You don't want to influence the decision either. If you really can't have anything to do with the matter. if you have a conflict of interest and are required to recuse yourself. And when they know or have reason to know the action could confer a material benefit. So you are requiring recusal when the person doesn't actually know that it would confer a benefit on them?
I will just say for context on recusal on that section, that came from the comptroller's model code, section 806. That's
Right.
not in state law.
Yeah, I don't think that is a very good code. And I think the comptroller doesn't really know very much about local government ethics.
Okay, so how did you think this should be changed?
Well, let me go to the way it works in the code that I draft.
Yeah.
Do you remember that section where we listed those people and entities with respect to whom an officer or employee may not use his or her official powers and duties to confer a benefit? Well, the recusal provision, the transactional recusal provision in the code that I draft refers back to that section and says you must recuse yourself in matters involving anyone listed in section, whatever that section number is.
And does it define recusal? Will you point us to that
Well,
section?
Yeah, let me scroll.
I found it very helpful,
23.6.
23.6, to have a definition of recusal so that people recused know or should know what it means.
Yeah, and look at how it elaborates. This is no town officer or employee shall participate in a decision, that you track that, or take any official action requiring the exercise of discretion, you track that, including discussing, deliberating, or voting on a matter when he or she knows or has reason to know that the action may confer a direct or indirect material, financial, or other benefit on a person or entity specified in section 23-4 of the chapter. And that refers back to that list that we pointed to earlier.
Right.
So this does include
The main-
or reason to know. It does include a reason to know, but it teases out the what we mean by not taking action to include discussions, deliberations, and
Right.
votes, and then refers back to the list in section 23-4.
Yes, which is all fine. I think that we kind of do that in our first sentence. What we've added that I found very helpful is once recused, they should leave the room. Well, very, very
They
specific.
can't vote, they participate in any discussions or communications, including email.
Email or text. I think that's helpful to add that, but
We're right. I think we were concerned that even though a certain person in particular had recused from a meeting, he was still maybe talking about the issue with fellow board members outside of the meeting. We wanted to make sure that didn't occur.
Well, those are two different things.
Yeah, there was
agree.
more than, yeah, go ahead, Stephen, but there was more than that. I remember when
Right.
you said, Stephen, that recusal and abstention were not sufficient in certain cases.
That's true.
with
In
this-
certain cases, they're not right. But
Yeah, that-
so let's take these one at a time. First of all, the Attorney General has, over the years, opined that when somebody recuses themselves, they should leave the room.
yeah.
I don't think that's necessary. I think that if somebody recuses themselves and goes and sits in the back of the room and does not participate, that's sufficient. They can't participate, but these meetings are public. Everybody can view them on the video. The town is full of gossip and information. The reason to exclude somebody from the room is if you think that their mere presence is going to be such a powerful influence to the decision makers that they're going to be unable to make the decision without taking into consideration what that member would want. I think that's, a remote idea that really isn't practical. I represent small municipalities. Shelter Island is a small municipality. If you had sophisticated chambers where someone could retire to and listen to the broadcast and know when the discussion ends and come back into the room, you know, that might be a little bit, you have that? You have that?
No,
The door isn't that
It's been an
soundproof.
issue here, Stephen, and I think that we would like to define full recusal as leaving the room, not just going and sitting in the back.
Yeah.
I think that's in everybody's interest.
Stephen, if somebody was the chairman of a committee and was the only expert in that particular field that they were discussing,
And that's the point.
and had to recuse. But yet if he was sitting in the room, I don't think it was the same.
There's pressure
We have, I think that our rule, we've been applying it and it's been working.
and
And
working.
it's a bright line. You're either in the room or you're out of the room.
Yeah.
I think that's better in our situation. It's worked so far.
That's our sense.
yeah, every attorney, Stephen, not to disparage your advice, but every attorney who I dealt with in these situations prior establishing Board of Ethics brought the scenarios of rolling the eyes, sides and whispers and discussions in the audience, right? Sitting, like, let's say, a member of the committee of the board sitting next to the client, right? Even though it's visually on the other side, they're sitting next to the client and creating the appearance of inappropriately, whispering, during the hearing. And we had that situation actually in the past. I remember a member of the board giving advice to his client during the live deliberation of the board.
And it's worked for us to have that bright line.
Well, I don't, this is not, in my view, an important issue. If that's what you prefer, then that's fine. I just have never, in all the years that I've represented municipalities as their ethics counsel, I've never had a problem of the type that you describe, ever.
Okay.
So,
Well, we appreciate you raising it. Let's move on.
Yeah.
all right. All right, I'm looking at, this concept of sporadic recusal. What
is in-
I think that's kind of a vague term. What I generally say,
Where are you in the code?
well, it appears both in 8-8 and in 8-9. In other words, if you have an investment or a position of outside employment that's going to require more than sporadic recusal, that's an indication that the positions are incompatible. Here's the rule on compatibility of positions, and the same applies to investments. It comes from a Court of Appeals case decided in 1874, People X. Rel. Ryan versus Green, in which the court said that in the absence of a constitutional or statutory prohibition, you can hold two positions provided that the two positions are not inherently incompatible. The way you determine whether two positions are inherently incompatible is you examine their duties. The classic example of two incompatible positions is chief financial officer and auditor. You can see how the duties of those two positions are in conflict. So, if you find, it's sometimes said you can't be your own boss.
Yeah.
Now,
This is
if you've
weird.
gone through that analysis and you find that the positions are not incompatible, they're compatible, and therefore you can hold both positions, that doesn't mean that a conflict of interest might not from time to time arise. If it does, that conflict is cured by recusal.
But this is
However, if recusal is frequently and inevitably required, that's an indication that the positions are incompatible because one of them is preventing you from discharging the duties of the other. So the
Understand.
phrase.
But this is referring to investments.
Understand that. And this issue has come up in one case here.
right?
that you might be able to see the opinion, but we're talking about
I
investment.
know what we're talking about,
Okay.
but please follow me. Where the term sporadic is a vague term. And the reason I discussed that other principle was to explain that the term that is frequently used refers to frequent, and if you're required to frequently and inevitably recuse yourself, that is an indication that the two positions are incompatible, or in this case, that the investment is incompatible with your official duties.
Yeah, and when we drafted this, we talked about that word or this word sporadic, because it's not in state law, like you say. And if it were frequent recusal, would that meet the
Right.
state law better? Sporadic was a judgment call on our part to try to describe this to people, right?
Yeah, I don't remember the
Investments.
conversation.
If it was frequent, I don't care if it's frequent or sporadic, as long as it's clear. Would that meet your,
I think frequent is clearer than sporadic.
fine with me, I don't care.
Yeah.
I don't want.
Okay.
I think that'd be fine, Stephen. I mean, especially because it's already in the state law, especially on the two half.
Well, it's not in the, it's not in Article 18. That's a common law principle.
Right.
Okay.
Okay.
8-9. This is the compatibility. This is Ryan versus Green.
Correct.
Okay,
And-
and,
And I think rather than that may be in substantial conflict, you want to instead speak in terms of compatibility. You can't have private employment that's incompatible with your official duties.
That would be incompatible.
Right.
right, we attempted to repeat 806(1)A here, and, or no, 805(1)A of state law. And the main problem we had in there is we conflated subsection A1C and D, and we need to separate that in this redraft. As we've talked about
All right,
before.
but why are you going back to that? I don't understand.
That's-
Yeah, you're talking about B. I also noted that there are two separate and distinct concepts that are somehow combined in B.
That was just a drafting error.
Yeah, so we do want to separate those. And you're talking about a change in A too, Stephen?
Yes.
We're in
Well,
8,
the-
are we in 8 or 8.5?
8, 9?
A, the preamble in A, rather than may be in substantial conflict. That's where you want to introduce the idea of compatibility.
8, 9A,
What did we
okay.
come up with?
And I just want to also note that in addition to conflating two different concepts in B, you also are inconsistent in the use of your term board in one instance and agency in the other. And you might want to instead use the phrase department, board, or agency.
Okay. Let's draft that out and look at it. You appreciate
That's the one that that's the drafting error is in B of this, 8, 9B.
B, yes, yeah, it'll be separated.
Yeah, it just got, that was just,
I didn't catch it.
it was drafting
Right,
error.
and the prohibition against contingent fees is not limited to your own department, board, or agency. You may not agree to receive or receive a contingency fee in connection with any matter pending before any town, board, department, or agency.
Okay, yeah, we want to fix 8, 9B so that it repeats state law exactly.
We'll fix.
Right. And then C is redundant, as to contingency fees.
Let's see, somehow I thought that was 805A1D.
I think we just,
Oh, I guess it's not. Yeah, that's part of the
that's part of the drafting problem.
drafting it.
Yeah.
Right. So we just want to repeat the
We'll
state
fix
law in
this.
that section.
We'll fix this.
Okay,
Right.
let's go
Okay,
on.
8-10, future employment. I personally feel that this provision is too restrictive in this respect. There should be two post-employment restrictions. The first one is temporary. It's called the revolving door, and the second one is permanent. The temporary ban, in my view, should only be on appearances on behalf of a private sector client or customer, appearances before your former board, department, or agency. And by appear, I mean be the face that walks the application in, be the signatory on the bottom of it, or on the transmitting letter, send the email, pick up the phone. You can't be the one communicating with your former board, department, or agency, because that runs the risk of creating the impression on the part of the public that you will have an advantage over others in dealing with your former colleagues. So there's a cooling off period of 1 year. In my opinion, that same logic does not apply to what are called back office services. I have no problem with a former town officer or employee sitting in their new office, telling their new colleagues how best to approach the town, who to talk to, how to fill out the application, what the process is, even helping them to fill out the paperwork and prepare it. The knowledge that they acquired while they are employed by the town belongs to them. That's their personal resource to market to a new employer, and I think they should be permitted to do that, because I don't think that creates a bad appearance. I will say this, though. While Article 18 doesn't limit these back office services and doesn't even deal with post-employment restrictions, state law does with respect to state employees. If you're employed by the state for a period of time after you leave the state, I think their rule is 2 years, you can't even provide back office services.
Yeah.
I don't think that makes sense. I think people need to be able to make a living after they leave town government. And, particularly in an area like Shelter Island, your knowledge and expertise may be in a limited area where there's a limited number of potential employers and certain specific type of work that you are eligible to be employed to do. You should be able to earn a living.
I think we talked about this last meeting, and there's some consensus to do that, make it less draconian. I don't want to speak for everybody, but so that an ex-employee can represent, but not appear in front of.
Right.
I think there's consensus on that.
Represent isn't the perfect word because it implies you're representing them. Yeah, yeah, it can,
Nope.
yeah.
Well,
It's open meeting.
You don't need to say what they can.
Render services to.
Yeah,
you
so
don't-
let's,
You don't need to say what they can do. You just need to say what they can't do. And what they can't do is appear before their former board, department, or agency on behalf of a private sector customer or client within 1 year after termination of their town employment.
I think we're
We're okay
in
with that.
consensus on that, so let's see the redraft.
Oh, I'm going to do the redrafting, right?
You are or he is?
I am.
Okay.
On
All right.
8-10, toward the end of that section, almost at the very end, you use the phrase any particular transaction. I would use the word any particular matter. That is the terminology that is used throughout the state. It's a particular matter ban.
Okay, let's move on.
8-11.
Wait a
That's
minute,
where,
can I interrupt? So this is the lifetime ban
right,
in C.
Yes.
And that's a little, that almost sounds harsher than the 1-year ban.
Well, the lifetime
It is.
ban is on particular matters, a particular matter, not a particular type of matter, a
Oh.
particular matter.
Got it, okay.
That already.
Yes, so that's what the lifetime ban should be on, something that they worked on here while they were,
Can
they
you give
can't do.
us some example?
But they can't even work for them?
I'll give you an example. No, it's not, you're not restricted from working for somebody. Here's an example. I don't know if Shelter Island is organized in this way. If it isn't, it's a hypothetical anyway. You are in the highway department of the town. Your job includes supervising road crews sent in by independent contractors to either pave or stripe the town roads. You're at a particular intersection on Monday, supervising the work at that intersection. You put in your papers and you retire, and you come back next week or next month at that same intersection. Now the foreman of the crew employed by the independent contractor working on that same project. That is prohibited. On the other hand, I can work for that same independent contractor on a project elsewhere in the town. It's just that specific matter that I handled while I was employed by the town. If it's a different site,
I get it.
Okay, we get it.
We,
okay. 8-11, personal representations and claims. Here, you're saying spouse or minor children, rather than, I would add dependent or member of your household. And I would also say other than representing them before your own department, board, or agency. I don't think you want someone representing even a family member or themselves before their own board, department, or agency.
You're talking about before any town other than that on which the employee serves?
Yes, you can. I think you should be permitted, without receiving a fee, to represent yourself, your spouse, your child, a dependent, or a member of your household before any town department, board, or agency other than your own.
Makes sense to me. I'm not sure where we got 811. It might have been
No.
the comptroller's code.
All right.
Okay, so town resources. It's unauthorized or personal use. It's unauthorized or personal use. I don't see the word
User for
unauthorized.
personal or private purposes?
Yeah, I mean, personal or private.
yeah, may,
I would say unauthorized or personal use. And in your list of what town resources include, I would add compensated town time. Compensated time.
Use town resource authorized by law. Part of their compensation.
Okay, I think we got this section out of the employee handbook here.
I don't think there's
Fine,
anything.
to make it clearer.
I'm not sure what we're supposed to change here.
He wants it unauthorized in front of personal in the first sentence.
Because we accept authorized.
Right. And something to deal with compensated time.
Right.
as long as that's all consistent with the town handbook, it's common sense.
Okay.
All right,
So the next comment I have actually recurs in a number of places. I don't think the town code should say what Article 18 says. It should say what it says. And so 8-13 says Article 18 requires no officer or employee may have an interest in a contract, etc. This is, by the way, the section that we spoke about, prohibited interests in contracts
yeah,
earlier. You know,
We didn't want
I
to quote the whole article.
It was huge.
That was what happened.
that is, we didn't want to,
want to have a whole quote of Article 18, so we just
Right.
referred.
but I shortened it and paraphrased it and have it, I think, in a clear way in the Southampton Code.
which part of that, Steve? Can we find that?
It's 23-5.
Five.
Yeah, this is that long list that we
It's very long.
didn't want to put in ours because of the length of it, you know. the
Right,
bank
but
account.
you're not regulating lawyers. No one's gonna go look at Article 18. No one is gonna read the Shelter Island Code and go to Article 18.
They're going to get bored reading this.
That's for sure.
They can get bored, but they're on notice.
I guess we also thought that this was a situation in which it was unlikely to be a problem, but maybe that was,
No, this is
Wishful thinking.
this is really the centerpiece and most serious section of Article 18. It is very serious because it's a crime. And it limits the town's ability to lawfully enter into a contract. It
Right.
only applies to a limited number of people. You're right about that. It only applies to people who have the authority to approve the contract, to approve payments under the contract, to audit bills rendered under the contract, or to hire or fire anyone who has the power to do or duty to do any of those things. And that power and duty arises if they have it individually or as a member of a board. And this is one of those instances in which recusal does not cure a violation. So the
Understood.
town board may not approve a contract if a benefit from that contract flows to a member of the town board, for example,
Understood.
even if that board member recuses themselves.
Right, with regard to contracts.
Yeah, right.
And we're aware of that. That's the most serious misstep or prohibited thing they can do because contracts could be reversed then and have been.
Right.
No,
Exactly,
do you
exactly.
really think that we need to list all 14 exceptions?
I would,
That's the area that we kind of tried to avoid by just referring to Article 18, exceptions. I mean, there's one in there, $750. Otherwise, we're not, what do
what is your goal? Your goal is really, your primary goal is to guide and protect honest town officers and employees and help them to avoid unintended ethics violations. It's not, this isn't about morality. It's not about inculcating moral values into the town officers and employees. They have the same degree of moral sophistication that we do. What it is about letting them know what conduct is and is not prohibited.
I think it's okay. It does spell a lot of things out, which,
like
Yeah.
the contract renewal, for instance, and
yeah,
exception number 8. Other things, very specific.
I was gonna say our code is long enough as it is. Why not hit this?
Well, yeah,
I mean, it does, allow people to look at these situations, yeah.
Yeah, it's, Deborah, well, we got, Stephen thinks we should put it in, all the exceptions spelled out.
But we were trying not to because of, we
Space.
felt that everything was getting.
Yeah, we'd have to buy a whole issue of the Shelter Island Report. Okay, well, I think we're heading that way. Yeah. Thank
Okay,
you.
next thing I have is in confidential information.
15.
15, yeah.
Yeah, it is. I have a couple. I very much dislike the state law provision that this is based on, because it doesn't tell anyone what the term confidential government information means. And by the way, you don't have the, you say confidential information, it should be confidential government information. Let me just go to, let me see how,
mean information about the government or about a person?
well, let me find that provision. I don't want to speak off the top of my head on this.
My notes say we took it right out of 805A2.
Here. Yeah, no current or former town officer or employee shall disclose confidential information concerning the property, government, or affairs of the town, or any other confidential information of an official character obtained as a result of town employment, except when disclosure is required by law or when such information is otherwise available to the public, nor shall he or she use such information to advance his own, what is it? I'm cut off here, just need to.
Where are you in the, you're in the Southampton Code, I assume,
Yes,
right?
23-16. So there's, I think that's a sharper, clearer rule. That's in B. But then in A, we define what we mean by confidential information. And there are two prongs to the definition. It's information that is prohibited from disclosure by federal or state law. And the second prong is information that the town has the discretion under either the Freedom of Information Law or the Open Meetings Law to withhold from public disclosure, and has lawfully exercised that discretion. So therefore, the town has lawfully designated something as confidential, and it would be a violation, in my view, of the Code of Ethics to disclose that. So for example, let's say you go into executive session. That is discretion that the Open Meetings Law affords you in specific types of, to discuss specific types of matters. Then you come out of executive session, you adjourn the meeting, and one of your members sets up a soapbox in front of town hall and proclaims to the public what was discussed in executive session. That, in my view, would be a violation of this rule. But on the other hand, if you go into executive session and discuss something that you're not permitted by law to discuss in executive session, and the person comes out and does the same thing, in my view, that would not be a violation of this provision.
Okay, that makes sense to be more specific there. Thanks.
Okay, next, gifts. I don't know what is meant by directly or indirectly solicit a gift. Here's essentially what the rule is under Article 18 for gifts.
It is in the first sentence of the Southampton Gifts Code.
Right.
Directly.
Directly or indirectly solicit any gift. I think we got
Yeah.
that from probably the
Probably.
controllers, but
You know,
If there's something that needs to be clarified there, let's do it.
I think it's pretty clear.
Yes, it's 816.
But yeah, actually, I think, so the Article 18 says that you may not solicit a gift of any amount or accept a gift having a value of $75 or more under circumstances where it would appear that the gift was intended to influence an official act or reward an official act. That's a terrible rule because it's vague and unclear and doesn't give adequate notice about what conduct is prohibited. So, so in Southampton, we added the following. No town officer shall directly or indirectly solicit a gift or other benefit from a person who has received or sought a financial benefit from the town within the previous 24 months. So if you're going to ask for the gift, you have a duty to investigate. Then the next next paragraph applies not to rules that you're requesting, but I'm sorry, not to gifts that you're requesting, but gifts that are offered to you without you having made a request. And there you have no duty to investigate. You can't accept the gift if you know that the person received the financial benefit. You're not under a duty to investigate. Then
Wait,
Then-
could you go back? Because we actually encountered something similar where a gift was given. I don't know how to say this on tape. And then a favor was
we'll speak
requested
hypothetically.
sometime later
Right.
after the gift was given.
Right.
Well, aren't we talking, are you including political contributions in this?
No, absolutely
Okay.
not. No.
Didn't
Oh.
think so.
Okay.
But why not?
Because they're a different species of animal. Campaign contributions are regulated by the election law. Gifts are regulated by the ethics law. Campaign contributions are a form of protected political speech, protected
Wow.
by the First Amendment of the Constitution. And there are all kinds of rules and reporting requirements. And finally, campaign contributions generally go to a campaign committee and not to the candidate directly.
Yeah, as we've discussed previously.
I
Okay.
feel like this is excessively,
So then it's just this, yeah, there's a whole list of.
What? Yeah, what do you think of? So you're recommending the long list from the,
pages.
Well, but each of these paragraphs, it does something different. So I
Yeah.
just want to run through them, please.
Sure.
So I told you what A and B do and say. C incorporates really a provision from the criminal law, which many people are not aware of. You all know what bribery is. Bribery is a corrupt deal made in advance.
Yeah.
That can be either a felony or a misdemeanor, depending upon the circumstances. There's a lesser crime of giving or receiving an unlawful gratuity. If anything of value, it starts from $1. There's no $75 threshold. If anything of value is given to a government employee for doing something that it was their official job to do and for which they're not entitled to additional compensation, that's a crime for both the gift giver and the gift receiver. It's a misdemeanor. So that is incorporated in C. There's no tipping in government. And it's a concept that many people don't know about and violate to their risk. And, it's not, I don't view it as my job to eliminate every ethics violation from the face of the earth. I regard it as my job to give people the information that they need and can use to protect themselves. So C says no town officer or employee shall solicit, accept, or agree to accept any gift, tip, or other benefit for having engaged in official conduct which he or she was required or authorized to perform and for which he or she was not entitled to any special additional compensation. At least you're putting people on notice of that rule, which is contained in the penal law. And
this-
I'm sorry, go ahead.
Stephen, it's another example of something that we looked at the time and decided we
Right.
want to have another 2 pages on this. Now, maybe we should.
It's not a question of pages, it's a question of what people are going to be able to read and understand and continue reading.
Yeah.
Not saying, oh my God, oh my God, oh my God, and just keep going.
But I'm sorry, that I need to answer that in 2 ways. Number one, there should be a plain language guide that accompanies this. If you can see what I'm holding up, this is the booklet for the town of Huntington. All of the municipalities that I represent as Ethics Council prepare this booklet. It has a plain language guide in the front, and it's followed by selected provisions of the code. This should be distributed to every town employee. Secondly, there should be ethics training. There should be periodic, regular ethics training. People in positions of policymaking positions should be trained every 2 years. Others should be trained at least every 4 years. And I do that in all of the municipalities that I represent. And, people grumble about having to sit there for an hour or an hour and 15 minutes and hear me pontificate, but you get the message out. And the more training that we do, the more the Board of Ethics receives requests for advice.
We're all
Training
for
is-
both of those things.
Your mission, really, in my opinion, your mission, the mission of an ethics board, is to get the message out. Because we're
Yeah.
not trying to bring evildoers to justice. We're trying to prevent the ethics violations before they occur.
Stephen, in your booklet, does it contain, say, this laundry list that you have here, or the one we just talked about before? Is that in your booklet? As
Yes.
well as in the ethics?
Yes. The booklet has a short 2-page plain language guide. And it's followed by sections, starting with section, 1. In your case, it would be 8-1. And going all the way up to and including what in the code that I draft is the transactional disclosure requirement. We don't include all the administrative provisions because that would make the booklet too long. And what we're trying to do is educate people about what their duties are under the code.
You got a copy of that?
Yeah, we have a
Yeah.
copy, and Deborah's gonna write one for us. Right, Deborah? Can't hear you.
Sorry, I muted again. I did read it after our last meeting. I looked over it. Yeah, it's really short. I mean, it's very,
And that's all that people are gonna read.
yeah.
Yeah,
And
so,
Stephen will work on that. Yes, I take that on.
okay,
Okay, so then the next thing that follows in this Southampton provision that you're looking at is the Article 18 standard. Because whether we like it or not, Article 18 applies in the town of Southampton. When I draft an ethics code, in order to avoid setting a trap for the unwary who might look at the Shelter Island Code, and think that they're looking at all of the rules that they must comply with without realizing that there's also a state law that applies to them. In order to avoid that, we incorporate all of the Article 18 provisions in the local code and then add on to those.
what are
And-
you referring to specifically?
Right now,
These gifts, he's referring to.
in the gifts?
Yes, I'm still in the gifts.
Yes, sorry.
It's D. We're up to D.
Okay,
And
thank
this
you.
is essentially the Article 18 provision. And
D.
then that's followed by E, which is a list of exceptions. And these exceptions come from the Lobbying Act. The Lobbying Act does not regulate the gift receiver. It regulates the gift giver, but it's a very sensible and clear and appropriate list of exceptions, gifts that you are permitted to receive, such as gifts to the town, gifts from a personal a friend or a family member, gifts on a non-recurring special occasion like marriage, illness, or retirement, provided that they're reasonable and customary. The knickknacks that they have set out on tables at conventions that you go to. You know, you can take the coffee mug or the notepad that they're giving away. Awards and and it goes on. It's a very sensible list. And that's the gift provision.
Okay, so,
Okay, so disclosure in certain applications, again, I wouldn't state what Article 18 states. I would state what the Shelter Island Code states.
well,
We actually have
that's a
that.
separate section of the code. We don't have it here because it's covered elsewhere. We're just referring to it,
If,
you know, the zoning code and so forth. They have other disclosure requirements.
Well, but Article 18 does require that applicants in land use applications disclose the identity of any state or local official who has an interest in the applicant. So that should be a provision in the Code of Ethics.
We do that, and we did do that prior to the code of ethics, right? So isn't it?
yeah, that disclosure is required if they file for a variance or
Right, according to those laws.
according to those departments. I don't know about the law governing those departments because
Other sections of the code that pertain to the zoning board of appeals, for instance, I
Right,
think.
but the Board of Ethics shouldn't abdicate the regulation of ethics violations. And because the state legislature, in its wisdom, chose to have that be a provision of Article 18, it should be a provision of the Shelter Island Code of Ethics.
Mhm.
And I wouldn't just merely refer to the fact that Article 18 says it. I would say it. I would have it be an affirmative duty under the Shelter Island Code of Ethics. The same is true of B. You say Section 8095 provides that.
Is that in the Southampton code, Stephen?
Yes.
Here I see
scroll down
applicant
to-
disclosure,
Yeah,
2321.
Right.
And so it is exactly there in 2321.
Right.
And I'm sure that our reasoning was already in the Shelter Island Town Code somewhere that regulates the zoning board of appeal, or zoning board of appeals already does it under the state law, whether or not it's in the local code.
Yeah, but the fact that most municipalities have this in their application form
Yeah,
doesn't obviate the need to say it as a rule in the Code of Ethics.
makes sense to me. We did actually get the ZBA to, or the planning board to improve their application packet to follow state law with regard to all this disclosure for practical purposes, but we cited the state law, probably not or maybe this section of the code, which is kind of a shorthand.
Mhm.
But if, makes sense to me to, I mean, all of a sudden it veers over to land use applications.
Right,
And
right.
do we have authority to investigate, you know, failures to do that in the land use application?
Oh, yes, absolutely. It's an ethics violation. It's not a violation of the building code or the zoning code. It's a violation of the ethics code.
Then we should lay it out here, I think. What do you guys think?
Yeah, if it's violation.
Yeah.
I don't know.
It could be just in the zoning board, like policies or something, where I think it's on their forms that they have people fill out. according to probably Article 18. But
Right.
it may not be in the local code at all.
We also reference the planning or the building department.
Yeah, all of those have,
Right.
okay.
Okay. The next thing I have is in 8-18A. This whole A, that belongs if anywhere in the preamble to the code of the entire code, but I don't think you need it at all. I would eliminate it. What the town board believes, what Article 18 permits, that's not appropriate. This, this is, you want to set forth regulations here. If you feel it's important to say these things, they belong in that preamble that's at the very beginning of the law. But I don't think it's necessary to say these things.
And we want to modify it.
Yeah, right, and understand that may be a good reason. What we have found, though, is the preamble, it doesn't have, the preambles, when you look up Shelter Island Ethics Code,
Preamble
it doesn't include the
disappears.
preamble. That's why we wanted to have a little mention of our, legislative intent or purpose in there. But if it serves no purpose,
It doesn't, that if the board wants an independent ethics board, they should appoint an independent ethics board. And, Article 18 permits the creation of a board of ethics. Therefore, they should create a board of ethics. You don't need to say these things.
okay, let's look at B.
B, I don't think you need to say all of whom shall reside in the town, because the law requires that requires that anyway. It doesn't harm, there's no harm in having it there. Staggered 5-year terms are good. I don't know why it says who shall serve without compensation to be appointed by the town board for set. I'm just not sure of the language, but that's okay. A majority of such members shall be persons other than town employees. We've discussed that already. But the board shall include at least one member who is a town employee. That's where that language is going to need to be changed. In C, conditions of Board of Ethics membership. Again, I think this paragraph is overbroad. For example, any local shall not be an officer of any local, county, or state political party. I know what that means. Association, I don't know what an association is in this context. A club is a very informal thing. You have no political authority as a member or even an officer of a local club. If you think that it creates a bad appearance, you can regulate that. But, the club is not the same as a committee. A political party committee is actually an organ of the political party. A club is really just, a social thing, and, you motivate volunteers to go, ring doorbells and carry petitions and that sort of thing. Independent political committee, subject to regulation of the state election law. That's okay. Or a campaign manager, consultant, or treasurer for a political party committee or individual election campaign committee, that's fine, or has served in such political capacity during the past 24 months. I don't know why you want to look back. I don't know why you want to look back. Personally, if I were drafting this, I would eliminate that last clause, or has served. 2, again, here we're talking about recusal has become prevalent. Before it was more than sporadic. Now it's prevalent.
Yeah, what's the other phrase we talked about? Frequent?
Frequent, yeah.
Where are we?
Oh, prevalent,
We're
I
in,
say it, they're prevalent,
C2.
18C2.
frequent.
You know, if
I
we're
think-
going with frequent, we should say frequent there
I
again.
know, this was from something that you had in place. I never worked on this, so.
What our thinking was when we put this in was that
This-
we didn't want people in the town to say that the ethics board was completely comprised of members of the Democratic Party.
No, I understand that. I just think we must have gotten this from some other model code.
Yeah, I think,
By the way, I don't know if this is practical for Shelter Island, which is kind of unique in its isolation and its size. But in the codes that I draft, to the extent that I can do this, I provide that no more than 2 members of the 5-member board shall belong to the same political party.
yeah, we
decided
talked
not to
about
do
that
that, yeah.
notion a few years ago and decided not to make it, you know,
But
political.
what we decided to do was just to try not to be active.
Okay, okay,
That-
Okay,
okay. I mean, you know, one size does not fit all. All right, now on C3E. You know, in the Old Testament, Moses was punished by God for a single act of misconduct and deprived of entry into the promised land. Do you want to be an Old Testament Board of Ethics? A single violation of the Code of Ethics is grounds for removal of an ethics board member?
Well, this may be removed, it doesn't
may.
say.
It says may.
Okay, you're right about that. It says maybe. Okay. Um, uh, and again, in D,
Yeah.
it's, I have 2 issues with D1. I mean, I have issues with the language. You're talking about the authority of the ethics board, and then you're talking about what town officers and employees may do. If you're talking about the authority of the ethics board, you should be addressing what the ethics board may do. You know, the ethics board may respond to requests for advisory opinions. That's just to make it, you know, the parallel construction.
yeah, I understand.
Okay, and the advice, we talked about this in a previous meeting. I think officers and employees should be permitted to seek advice about themselves or someone they supervise. If you're a head of a department responsible for supervising your department, and you're uncertain whether somebody's conduct is or is not a violation of the Code of Ethics, you should be able to go to the Board of Ethics with that question.
And then the result would be confidential to the supervisor? Would it include the employee talking? Who does the result go to?
Well, it's not a complaint. It's a request for advice. And then the supervisor would have to take whatever action or not that the supervisor deemed appropriate.
Again, who does the result go to? The supervisor, is it a confidential opinion?
For example, what if we had to bring the employee in
Right.
to resolve the issue? It loses its confidentiality there.
Well, if you have reason to believe that somebody has violated the Code of Ethics, then you can sua sponte, conduct an investigation.
Yeah.
You don't have to disclose to the employee that you issued an advisory opinion to their supervisor, but I can't imagine that the supervisor will not want the opinion to go to the subordinate and even provide the opinion to the subordinate himself or herself. And the answer to the question really depends upon the facts and circumstances. If there's some serious ethics violation that you become aware of, you're going to feel duty bound to get involved in enforcement. And some of the questions may be something that an employee is planning to do or has requested to do, or this can arise in so many different. There can be so many different scenarios under which this arises, but supervisors who need to be able to supervise their staff should be able to get opinions that relate to staff members that they supervise.
Yeah, I mean, it's that kind of thing's even come up with prospective people they supervise, like you want to hire somebody, what kind of person, what criteria. I just wonder where it would fit in. Is it a confidential advisory opinion to the supervisor?
Yes.
Does it go to the town board as a non-confidential opinion?
No.
Okay. What do you guys think about that? I'm okay with it.
Yeah, that's fine.
I mean, then,
But subject to, as I said, if in the course of considering that inquiry, you learn that something has occurred that you need to take action regarding, then you have the authority on your own initiative to initiate an investigation.
it makes sense to me, where a supervisor, is my employee, is this a problem? And then the opinion only goes to the supervisor, the employee never hears about it? It's,
I mean, it depends on the situation. Like I said, if we have to investigate, the employee
Yeah.
hears about it.
yeah, I mean, if we can be helpful, that seems like a good idea, doesn't it? Deborah, what do you think? Yeah, okay, let's try to include
Yeah,
something.
I'm sorry. Thank you for including me. Yes,
Yeah.
it makes sense to me. Yes.
Okay. Let's go on. And then paragraph 2, we're going to change probable cause to reason to believe.
And I don't think somebody needs to believe in good faith before coming to the board. They just can come to the board. I don't think there's a need to address the state of mind of the person who's making a complaint. And as far as I'm concerned, the complainant can be acting out of spite or out of political motivation or out of, some other improper motive. The motive of the complainant is irrelevant. The question before you is whether a violation of the Code of Ethics has occurred.
I don't think requiring good faith is a problem, but
You know,
I think we were afraid of a lot of spurious claims. Somebody gets pissed off and
right.
starts complaining, so.
But that's okay, because, you are charged with the responsibility of separating the wheat from the chaff. And I'll tell you, nearly all ethics complaints are without merit, nearly all of them. Because people don't know what ethics is, and they think that if something just seems wrong to them, it must be an ethics violation.
Okay, let's go on.
I liked when we had the long discussion about putting some sort of a qualifier in there, and I thought we carefully chose our qualifier at the time.
But why do you want the qualifier? If someone thinks that there's an ethics violation, or there may be, don't you want them to bring that to your attention?
Yes, I thought that what qualifier was about, whether we then needed to proceed with,
No.
vigorous action, or whether we, that's what I thought the qualifier was for, not
I have to
not
leave
to
it one.
analyze the person.
Right.
I have to leave it one. I
Right,
like to keep it one.
I know, we do have to wrap up
Have
in
to do the,
10
I,
minutes.
agree-
I have to
I
leave
just
it
want
one,
to say,
yes.
I agree with Deborah.
Oh,
The
thank you.
qualifier is that you have to make an evaluation of the complaint to
Not,
determine
we're not
whether,
looking at the, yeah, at the whatever of
Right.
the complainer.
right, yes, exactly, exactly.
I can see we're not gonna be able to get through this whole thing.
How much more do we have? I agree, but just out of curiosity, how much more do we have to go? Not that I think we should continue now, but just a
We do
question.
not have much more to go. We're getting toward the very end of the code.
We need
But-
an executive.
closed session before.
But we can pick this up again if you like.
Can we, yeah.
Yeah, I have a couple of comments on the letter that Duff sent out, so they're
Yeah,
really, really brief ones, but we need
What
to do that.
What we could
better.
do is the usual process of confidential email exchanges on that letter,
That's okay with
Yeah.
me.
That's fine.
talking about it here.
That's fine.
So
And,
in that case,
Duff, I request, I'm going to be out of the country starting Monday, but I can access the town email if you send me a personal text just saying access. I will come on if you ask me to. If
Okay.
you say there's something there to look at.
understood.
Okay.
I think unless there's any objection, we should do that.
Okay,
Finish this.
Finish this. Now. Is that okay?
That's fine.
I'm going to take back what I said about drafting it. I'm going to let
no.
Stephen draft it. Yes, no, yes, definitely. I am not going to redraft this whole thing, so.
Okay,
Yeah, there's a lot. I thought you were taking
You gotta
on a
go?
lot.
Sorry,
just a sec. One more public comment?
very complicated.
Yeah.
Great job. It looks like a lot of thought is going into what you're dealing. I think the idea of ethics and the board and all the employees of the town really should be aware of this. I don't think there's enough education.
Yeah.
And I happen to like, I sort of zeroed in on when you were going through it, but it's really a commendable project you're in, and it looks like it's it should, I guess, it finally gets to a particular point, but I guess it's still evolving. I guess everything always evolves, okay?
Yeah.
It's a worthwhile thing to do, long overdue.
Yeah.
You're doing a great job. Thank you.
Thank you.
Thank you.
I've learned a lot just sitting here. I should
Thanks,
know,
Gordon.
I feel a little insecure over it, okay, to be honest with you. The thing with gifts and so forth, those are really interesting things. I've had some personal experience in the city of New York over something as simple as a calendar.
Yeah.
Okay, our firm used to send calendars out, okay, to different municipalities, and I was called in on something that, it will let you go this time, but don't do that again, okay? But it's necessary. I mean, even the littlest things that we think are incidental, listen, years ago, we did a whole lot of things, okay, but times have changed and we need these things. Thank you.
Thank you,
Good
Gordon.
job. Okay.
Thank you. We'll stay in session. We don't have executive session. I see Amber's joined us. Thank you. Just to summarize, you can watch this 2 hours online if you want. And you'll see that Stephen's walked us through a lot of stuff, and we're gonna do some pre-drafting, and then we're gonna talk about it again at our next meeting.
Okay, all right, I will pay attention. Were you about to go into executive session?
No, we gotta leave in 5 minutes.
Oh, okay.
I have a dentist, Lori has stuff.
Oh, okay, okay.
Stephen, you wanna try to get through the end?
Well, what
Oh,
about the
sure.
letter? No?
The letter we're going to address through our usual email process.
Oh, okay, I didn't understand. Okay, fine.
Yeah.
Okay.
Okay, the next thing I have is on 8-18D4, which I think is redundant. And again, I think I would not refer to Article 18 and what it says. I would say what the Code of Shelter Island says. 8-19, investigations. Written complaints must include the name of the individual complainant. There again, I think you should accept anonymous complaints. It's better to have the name. because then you can follow up with any questions that you may have.
I think
Sometimes,
we agreed to that at our last meeting.
okay, fine, I'll move on. Again, the term frivolous on its face, I would use the reason to believe standard. Then the ethics board shall make a reasonable effort to obtain voluntary cooperation prior to exercising or enforcing their right to compel testimony. I don't think that, I think you should not handcuff yourself. Just, that doesn't need to be said. If you want to make reasonable efforts at the time to do something informally, you can do it. And the ethics board shall take steps to ensure that every individual's right to due process is protected. I would say the Board of Ethics shall ensure that every individual's right to due process is protected. You don't need the phrase take steps. 8-20. C, to forward its opinions responding to complaints or opinions on its own motion to the town board with any recommendations for disciplinary actions and penalties. You're not referring here to advisory opinions?
I'm sorry, I've lost the thread. Where are you at?
8-20C.
That's right. The opinions responding to complaints or to our own action
Okay,
are
so
forwarded to the town board,
for
not
opinions,
confidential advisory opinions.
okay, then I would say opinions issued on its own motion, to clarify that.
Yeah, okay.
And recommendations for disciplinary actions. Well, the code of ethics provides certain penalties. Does it state who is authorized to impose the penalties?
Generally, it's the town board. So when they go to them, they say whether or not we recommend any further action.
So so if the way it works in Shelter Island is that only the town board has the authority to impose penalties, including discipline, if that's the intent, I mean, that's not generally the way I don't think that's the best practice. I think the Board of Ethics itself should have the authority to impose penalties. The town board, while the town board is the governing body, it's a political body. The Board of Ethics is not a political body. And so theoretically,
Interesting point to discuss. Our prior council thought strongly that it would all be up to the town board.
right,
But you're saying that's not best practice.
not in my opinion. And in my opinion, anybody who disagrees with me must be wrong.
Okay, we're going to lose our quorum here. So I want to suggest another meeting.
Just let me know. I gotta go.
Okay.
Okay.
Okay, so we are going to lose the quorum. We will have to stop the meeting. And the only other thing that I want to do among us before we hang up is talk about our next meeting.
Yeah.
Is that okay?
All right, so can you just hold the meeting so it's
You make me want to explain what we're talking about, changing our bylaw to allow.
Can you adjourn the meeting?
Yeah, I move that we adjourn the meeting.
Yeah.
All in favor?
Aye.